Hello and welcome to the next episode of the Speed Mooting Podcast. My name is John Dove. On the latest episode of the podcast, Hayley and I are discussing mooting. So mooting is the theme of this episode. We're talking about a recent competition at which we judged and some general feedback and tips in relation to mooting. In addition to this, we have a little section where we discuss an exceptional hardship hearing, what it is and why they take place. And we also discuss Harry Potter and the legal world. So it's an interesting episode. It was a fun one. Tune in and we hope you enjoy. Okay, hello and welcome to the next episode of the Speed Mooting Partners in Crime podcast. I'm John.
And I'm Hayley.
And this is our fourth episode now. So we're starting to get into a bit of a swing of things now. And hopefully we're getting better with each and every episode. So hopefully you will enjoy today's episode. What should we talk about today, Hayley?
I think the first thing we were going to talk about is the exciting weekend we've just had.
Yeah, okay. All right, let's start there then. So for those of you that may have missed last week's episode, we were talking about how busy we were last week. And that at the end of the week, also known as the weekend, so at the weekend, we drove to Kent. So we literally drove, I'm not going to say the length of the country, but a good chunk, because we went from Liverpool to Kent, which took us at that time 5 hours, something like that.
Actually.
Yeah. We were. For those of you that don't know, Kent is actually not that far from France, to put it into context. So we basically drove to France.
Yes.
So a nice little drive down to Kent on the Friday. And then on the Saturday, we were judging at the KLS, so Kent Law School, and Thomson Reuters National Law Student Triathlon. So it's an initiative set up by Darren Weir at Kent Law School, and it's a brilliant day, isn't it, Hayley?
It is, yeah. It's absolutely jam-packed. So the idea is the competitors, which are teams of two from all different law schools up and down the country, take part in 3 major pieces of advocacy throughout the day.
Yeah.
So in this competition, they had to do an ex parte freezing injunction application, a huge mediation, and then they came to us because we were a court of appeal bench.
So it was an interesting bench. So there was Hayley, myself, and His Honour Michael Stokes, KC, former recorder of Nottingham. So quite the formidable bench there.
Yes.
So we judged some brilliant moots during the day.
We did. The calibre was really, really high.
Yeah, very impressive. And, well done to everyone that took part. You're very brave, taking part in 3 different challenges on one day. So hopefully people have enjoyed the day. And we were giving feedback, weren't we, Hayley?
Yeah.
And we'll talk about that a little bit later on, some of the general feedback that we were giving to some of the mooters. Yeah. So that was the competition element of it. There was also a Q&A panel whereby I sat on with a few other practitioners, and we were talking about, or rather answering questions from students in relation to applications, life and practice, tips and hints on how to get into the profession. So hopefully that feedback was helpful. And then it all concluded with a bit of fun at the end. So we had a mock trial. And in this scenario, it was a take on the classic story of Goldilocks. So Goldilocks has gone into the 3 bears' home while they're out picking berries. She goes to sleep. Lo and behold, Mr. Bear comes home, and he is charged with a Section 47 assault on Goldilocks. So I was there to prosecute the trial, and we had some good fun, didn't we, Hayley?
Certainly did, and I think you secured a conviction, didn't you, against the dreadful Mr. Bear?
I think we did. Thankfully, given it was his first offence, he got away with a conditional discharge, so he was able to go home that evening.
Yes. Yeah, no, it's really good fun, and the trial takes place after dinner, after everyone's had a few drinks, so probably the most rowdy jury you've ever
Absolutely, yeah. It's a good laugh,
it really is.
Yeah.
And I think the whole day and everyone that takes part in that competition just links back to what we were talking about in our last podcast, John, just about how important it is to take every opportunity that comes your way. So if you haven't taken part in that competition yet, I'm sure it'll be back, and we definitely recommend taking part in that competition.
Definitely, absolutely. So yeah, so that was our weekend, and then as you can imagine, we drove back on Sunday.
We're not still sat in Kent.
So as I mentioned, Hayley, myself, and Michael Stokes shared feedback with those that we were observing in our room, those that we were judging. And I think it's probably a good idea, Hayley, for us to just talk about some of the general pointers that we've seen, some general mistakes and some general tips that we gave in relation to mooting.
Yeah, definitely, because there was some common themes throughout the day, things that we were feeding back pretty much to every pair of our mooters. So yeah, there's definitely some themes that it's worth sharing with our audience.
Yeah, definitely. So I think the first thing, because one way that this competition is different to ours, for example, is that these were proper moots, so people were required to undertake research and draft their own skeleton arguments and exchange them in advance of the competition. Now, within the rules, there were specific guidelines in relation to how the skeleton argument should appear. Thinking off the top of my head, I think it was something like, no more than 5 pages. There were limits in terms of how wide the margins could be, the font that had to be used, the size of the font, the line spacing, etc. So when you've got rules like that, those rules are there for a reason. So follow the guidelines. If the rules say that you need to type it in a certain way, use a certain font, etc., do that. If you don't do so, effectively you've not followed the rules. You can be penalised quite rightly for that. So that's the first thing. Read the guidance very carefully in relation to skeleton arguments.
Yeah, I think the authority that people were citing, that was linked into the rules as well, wasn't it? So you're only allowed to rely on a certain number of cases.
Yeah.
And a couple of people had
more. Yeah.
So that's very, very simple things, but things like that is where you lose marks in these types of competitions.
Yeah, definitely. Yeah, get the simple things right. You might not score marks, but you just don't lose marks.
Yes.
And you don't want to be starting before you even go in and you open your mouth. You've lost marks because you've not followed the guidance there. Looking at a lot of the skeleton arguments I saw, the advice I would give is that a skeleton argument needs to be skeletal. So it's not your full argument. We saw a number where the skeleton argument was effectively a script,
and as very, very note tied to that script.
Yeah. So as we're following the skeleton argument, that effectively some mooters were literally reading the skeleton argument to us. The reality is, if you're going to do that, you don't need to be there performing advocacy. You might as well just submit the skeleton argument. Yeah. So the skeleton argument is there to be, as you said before, Hayley, the bare bones, and the idea of your oral submissions are to add flesh to those bones. So, imagine you've got your introduction, and then for each point that you're going to make, it's going to be what is the point and what's the authority for it. In very simple terms. You don't need to tell us everything you're going to say about that, because you're going to flesh that out when it comes to your submissions. So, it might be the clause in the contract is not valid because, very quickly, what in one line, the authority for this is, and then what you will do in your submissions, you'll take us through what the point was that was established by the authority, how that applies to the rules, how that applies to the clause that you're trying to set aside because it was a contract law problem, and go from there.
Yeah, and I think linked very, very closely to that point is the need to have authority to back up every single thing you say. You make the judges' lives very easy if you say anything and it's not backed up with authority, because our judicial intervention is naturally going to be, okay, thank you, where's your authority for that point? And if you don't have the case ready, it's so easy to fall down there. So everything you say, back it up with authority. It might seem repetitive at times, every point you say, point, authority, but that's the way the judges like it, because it's easy for them to follow. And I think a point leading on from that, John, is the use of bundles correctly.
I completely agree. People need to use the bundles correctly, and it starts with the skeleton argument. So the skeleton argument is the roadmap for the judge to follow. So normally you will be taking us through in a logical format or chronological format through your skeleton argument. So if you've got points 1, 2, 3, 4, 5 on the skelly, that's probably the way in which you would follow that through in your arguments. I can't see any reason why you wouldn't be going through in that order. And each time you're moving on to a new point, refer us to where that is in your skeleton argument. So you might say, so my second submission in relation to ground one, your lordships and your ladyships, you'll find a paragraph 4 within the skeleton argument. We can see that there. And then you say, and I'm going to be referring to the case of X and Y, which you can find at page 75 of the bundle, whatever it might be. And too often they might take us to somewhere in the bundle so that we can read a line of a judgment, but they hadn't prefaced it with, oh, and by the way, this is found at paragraph 4 of my Skelly. Oh, the case I'm citing is. So quite often we have people who were citing a line from a judgment without even telling us what case that came from. And it was quite confusing, and we'd have to say, which case are you referring to, and slowing people down. And it all stems on from that point, Hayley, of everything you say needs to be backed up with authority.
Yeah, and just not rushing either. So sometimes when people were taking us as the judges to the point in the bundle, they would immediately start citing the paragraph before we'd even had a chance to find it. So take a pause. It's at page 63, paragraph 20. Wait. And the judges will usually give you some form of affirmation. Yeah, I found it. Yep. They'll nod, they'll say yes. You can even say, does my lord have sight of the passage before you begin? There's nothing wrong with doing that, because I think this is a point of feedback you gave on the day. If the judge is too concerned with finding the place in the bundle and you're talking, the judge isn't listening to you. So that point is completely lost. So I think nerves plays a big part in moving very quickly, but try as hard as you can just to take your time and pause, and that's what comes with practice.
Yeah, absolutely. And coming back as well, we were talking about ways of not losing points. Think about simple things you can do within your submissions. So the correct salutation when you start is, may it please the court, or if it pleases the court. Start with that, because if you just jump into your submissions without, that sort of courteous salutation, straight away you can potentially lose a point for that. And also, if you are lead counsel for the appellant, for example, introduce yourself and your teammate, and introduce your two opponents as well. That's what you're expected to do. So make sure that you're introducing people. And it might also be a point to say which points of the appeal you will be dealing with. So in this particular case we were dealing with, there were 2 points of appeal, and that's generally quite common for a 2-on-2 moot. So you as a general rule, senior counsel will deal with point 1, junior counsel deals with point 2. We saw a few people that were mixing and matching, so senior counsel was covering parts of point 1 and point 2, and then junior counsel did, and that's a waste of time. You're not using your time effectively, because if you have one person that deals with point 1, they can go into a lot of detail on that. And then likewise with junior counsel, if they're dealing with point 2, they can go into detail on it.
One of the big themes that we said throughout the day is the main part of advocacy is all in the preparation. Mm-hmm. And this is another reason why we say it's really important not to be note-tied and not to have your skeleton argument existing as a script, because when the judges come in, as we did quite frequently this on Saturday, and ask you a question, immediately you've got to completely deviate away from your script, and a lot of judges won't take kindly to you saying, well, I'll deal with that in a minute, I'll come on to that later, because that's the order of your script. Doesn't work. The judge has asked you that question, that's the point they want you to address, and if you've prepared properly and you know the materials and you know the case law, then you should be able to, and we saw a few people do this really, really well, just jump right onto that point and then immediately take yourself back to wherever you finished on earlier. So judicial intervention is definitely one of the hardest parts of mooting, isn't it?
Yeah, you've hit the nail on the head there. If the judge wants you to move around your skeleton argument, do so. We did, as you say, 1 or 2 people that would go, I'll deal with that in a moment. So yeah, you can't do that. And as you say, judicial intervention, it can be the most important, probably is from my point of view, actually, because when you've got 2 mooters who are really good, present well, they've applied the law well, and have thought of strong arguments, sometimes that's the only way that you can distinguish between 2 mooters. So realistically, you want to be going into that moot thinking about which questions are likely to come up and how you can deal with them. So, I probably say this all the time, but think about where the weaknesses lie in your case or the strengths lie in your opponent's case. And that's a very easy line of questioning for the judge. That's low-hanging fruit for the judge. These are the easy questions and the most likely questions you're going to receive. So think about how you will deal with those questions. You probably have something sort of pre-prepared within your mind. Obviously not a script, but a general answer for those questions. If you've prepared for the moot properly, you'll be thinking about the weaknesses anyway and how you deal with those, maybe within your own submissions. And when the judge asks the question, there's nothing stopping you pausing for a second, having a little think, asking the judge for a second to think about it, or using a filler phrase. So don't feel the need to jump right in, because sometimes you might jump in and halfway through your sentence you think, there would have been a better answer. Mm-hmm. So although you thought about this in advance, take a second, just take a pause before you actually answer the question.
Yeah, and a judge isn't going to mind if you ask them, can you rephrase that, or can you provide some clarity? Are you asking me this? Mm. Because I think it was said a few times during the day as well that in real life, advocacy is more of a conversation with the judge.
Yeah. So
that's how it can work in mooting as well sometimes. Just have a conversation with the judge and you'll get them to the answer that they're looking for. And sometimes they already know what the answer is and they're just trying to help you get there.
Yeah, exactly.
So after the long trials and tribulations of driving to Kent and back, thought you'd do something different and spend more time in the car today, didn't you, John?
Oh yeah, it was only a 4-hour round trip backwards and forwards to court. So for today's venture, I represented a client in an exceptional hardship hearing.
What's an exceptional hardship hearing, John?
Oh, well, I'm glad you asked, Hayley. So an exceptional hardship hearing relates to motoring cases. So for those of us who have full driving licenses that we've had for more than 2 years, you can have up to 12 points on your licence, at which point you would then be given an automatic 6-month driving disqualification. Now, if an individual does tot up to 12 points, they can raise what's known as an exceptional hardship hearing in court. And effectively what they will do is they will say to the court, look, I need my licence because X, Y and Z. They'll explain to the court why it is that they would suffer exceptional hardship. And if the court finds that there is exceptional hardship, then they can retain their licence despite having 12 or more points. And then, of course, if they then receive any more points, the disqualification then takes effect at that point. So over the years, it's becoming more and more difficult to run the argument. As I say, what you need to show is you're not just there to show just hardship, because ultimately everyone's going to suffer hardship as a result of a driving disqualification, because the punitive element is there for a reason. So everybody naturally will suffer some form of hardship. The idea of this hearing is to show why you would suffer exceptional hardship, and only then will the court allow you to retain your licence. So there are 2 ways in which these hearings can take place. The first is that either counsel or a solicitor representing a defendant can present submissions on behalf of their client, so effectively present an argument as to the hardship that would be suffered. Their client would then go into the witness box, confirm under oath that those submissions are accurate, maybe receive some questions under cross-examination from the prosecutor or the magistrates, and then there'll be the magistrates will make a decision. The method that's finding favour at the moment, though, is where a defendant gives full evidence on oath. So effectively, it's almost akin to, well, it is the same as the way in which somebody would give evidence at trial. So a defendant at an exceptional hardship hearing would go into the witness box, their counsel or solicitor would ask them questions in evidence in chief for them to tell their story, and then once again, following on from that, they would be subject to cross-examination, and then their representative can make a final sort of closing speech at the end. So that's the hearing that I was on today.
So are they fairly common in criminal motion cases, or is it rarity these days?
Very common.
Very common.
Very, very common. So, for example, the court I was in today had 10 exceptional hardship hearings listed. It's so common. You think about how many people build up points all the time. You know, you think about it, when we were on the motorway the other day, we were seeing those cameras flash, 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 flash.
Yeah.
So, you know, people build up points all the time.
So it's very common for the hearings to happen, but not so common that the judges are persuaded.
Not so much these days, yeah. So I think the general consensus is that many, many years ago, 20 years ago plus, before I was in practice, apparently these hearings were relatively straightforward, and quite often people would be granted exceptional hardship. But over time, courts have taken a much more stringent view in relation to these cases. And so you really do, as I say, you really do need to show that exceptional hardship there. Yeah. So on last week's episode, Hayley, we were talking about our busy week.
It was a busy week.
It was a busy week.
We're still recovering from a busy week.
We've got another busy week coming up this week, haven't we? But not quite as busy.
Not quite as busy. So we're filming this on Tuesday afternoon. So in just a few short hours, we'll welcome our public speaking and debating Advocacy Club members for a nice session on debating. So that should be a fun one.
That's always a fun one. Yep, that will be good.
Yep, and then on Thursday night, after John's done a big round trip commute again.
Yeah, I'm pretty much travelling the width of the country this time.
Then we're off to London for a few days. So it's only taken me almost 4 years since I qualified, but I'm finally going to do my SRA admission ceremony. Thank you very much, COVID, for that one.
Well, at least you get to do it in person anyway. That's the main thing.
Yeah, so it should be really nice. Really looking forward to it. And we're going to spend some time in and around London at the same time. Yeah,
it'll be really good. Yeah, it's been a while since we've been in London, hasn't it? So it'll be nice to have a little walk around and see what's going on.
Yep. I want to go back to the little pub next to Gray's Inn, the City of York, if anyone knows it. That's one of my favourite spots to go to.
Yeah, I like it in there. I used to go there whenever I went down to London for my qualifying session. So it's a nice little pub, isn't it?
Yeah, really nice.
So it's always nice going down to the Inns of Court anyways. And I'm a member of Gray's Inn. And I always get sort of a bit of a Harry Potter vibe walking around the Inns of Court.
You're a wizard, Harry.
Yeah, definitely. You can see where the inspiration comes
definitely. from. I'm a little bit late onto the whole Harry Potter thing as well. I think I saw the first one when I was a kid and it came out, but then beyond that, I'd never really seen them. And Hayley, you've been showing me the films, haven't you, recently?
Yeah, so I'm a big fan, Harry Potter geek right back from childhood and still am today. And we got to the 6th film, and John turns around in the opening scene and says, "Are we ever going to find out who this Dark Lord is?" And I was just like, head in hands, no, John, you did not just say that. So I did make him go back and watch a couple of films again, because he clearly missed some pretty big points there.
Yeah, I think I must have fallen asleep through a few of them, which isn't uncommon, to be fair. I often fall asleep through horror films, don't I?
Yeah, in the cinema, no less. But yeah, for Harry Potter fans out there, we went back and watched the 5th film again, and watching John watch a criminal trial is something else.
It was unbelievable. So I'm trying to think back to it now. So we start, and I think midway through an opening speech, we have Dumbledore come in and announce that he's going to be a witness. He'd not been told that the hearing had been changed. So that was a bit shocking, number one. He then tells us he's going to be a witness, if I remember rightly.
Witness for the defence. Yeah.
Witness for the defence.
Witness for the defence. Albus Percival, Wulfric, Brian, Dumbledore.
Once again, why he's... And then I think he was there and then about to give evidence. And it's like, hang on, let the prosecution present their case first. And then... next thing, he then tells us he's going to be defence counsel as well.
Well, I don't think he tells us, he just assumes that role.
He just assumes that role, doesn't he? Yeah. It didn't even ask Harry, And it goes on and on and on. I need to rewatch this scene, actually, because Hayley was there with me giving a play-by-play commentary on this trial, and it was painful. It was painful to watch.
John hates inaccurate court scenes or court sequences in movie and television, so you can imagine how fun it is watching scenes like that with him.
Yeah, we need to do sort of a running commentary on these things, don't we?
It might be a segment. So if you've got any ideas out there of criminal court scenes or anything to do with law where it's not quite accurate, shall we say, then do send in your suggestions to info@speedrouting and we'll get John to give us some funny commentary.
No doubt we're going to be inundated with scenes from Suits whereby disclosure just doesn't seem to happen in advance of a trial, and
they get that little blue plastic wallet and then the next day they're in court.
Yeah.
Their court system must be far better than the UK court system, that's all I can say.
So that was interesting anyway.
Well, one thing we do have on next week is the legal session of Advocacy Club.
We certainly do. And next week, it's focusing on the bail application. So for those of you that want to go into criminal law, whether you're an aspiring barrister or aspiring solicitor, you will be involved in bail applications very regularly from the outset. So they're very common, both in the magistrates and in the Crown Court. So it's going to be a very practical session, but also quite a fun session as well. So I think that brings us to the end of another episode, Hayley.
I think it does, John.
We are 4 episodes in. It's going well so far. We're enjoying it. We hope you are too. The next one, it's a milestone episode, number 5. Maybe we do something special. Maybe we have like the Perry Mason theme tune as our outro or something for number 5. I wonder if the current crop of law students know who Perry Mason is.
If you do, let us know.
Comment below. Answers on a postcard. But yeah. So as I say, that's the end of the next one. We've discussed a lot. We hope it's been helpful. And until next time.
Bye.
Bye.